on the record in docket 22-01904. That's People, the State of Michigan versus Terrell Duncan. Will the parties please introduce themselves to the record?
Jake Wisty on behalf of the people.
And please the court, David B. Carter Jr. on behalf of Mr. Dunkel on the felony file.
Okay,
Although I would like to, even though I'm not appointed to the misdemeanor file, I would like to address that one as well.
fair. We can do that. This is the time set for preliminary examination. Oh, this is not. This is the time set for a probable cause conference on Mr. Duncan's file. Mr. Wisty, how are we proceeding today? And for the record, Mr. Duncan's not here, right?
That is correct, Your Honor, and I have a very logical explanation for that, and I'll be more than happy to address that when the court wishes me to.
All right, Mr. Wisty.
Your Honor, people would like this set off for review type hearing after January 25th, 2023. This is similar to the misdemeanor case Mr. Duncan had earlier this week, where this has been resolved pursuant to a global resolution on another file in circuit court. That 25th of January is the date of the sentencing. It would be the people's intent to dismiss this case after Mr. Duncan is sentenced. So that would be the people's request. And from speaking to Mr. Carter, the people have no objection to Mr. Duncan not being here at the probable cause conference. But I would defer to Mr. Carter for further explanation.
And he waived his 21-day rule on November 10th. Is that correct? I have it waived last time on November 10th.
That's correct.
All right, Mr. Carter.
Thank you, Your Honor. Apparently, my client failed to appear on the misdemeanor case earlier this week. On November 14th, we entered into a global resolution regarding the misdemeanor file, which I do not represent tonight. This file and an armed robbery file in front of Judge Aquilina. At that time, our global resolution was that he would plead to the unarmed robbery, no more than 24 months in prison. Actually, it was more like a sentence within a cell grade of 12 to 24 months, as that's where he fell on the sentencing guidelines. And that the misdemeanor case would be dismissed, and so would this case be dismissed. And he entered into that plea. So I truly believe that my client thought that, okay, these cases are dismissed now. I've entered into a plea in Judge Aquilina's courtroom. I would indicate to the court that he is on GPS monitor with Judge Aquilina, and I haven't heard anything like that's been violated.
I think there's good reason to adjourn past January 25th to dismiss, because we're going to resolve both these files along with what has already been a plea in circuit court. We're just waiting for sentencing, and that seems to make all the sense to me in the world. So I'm going to set. So I'm going to. We're not going to issue a bench warrant. Not issued. That. I got that right, correct. Issue, not issue bench warrant on this file. But on circuit court case. As part of those negotiations. And so we will reset our preliminary examination for sometime after January 25th. You can pick a date.
January 26th
Okay, January 26th.
at 8:30.
So that'll be after sentencing, after,
And the misdemeanor review will be that time.
okay, circuit court sentence. It'll be set for January 26th at 8:30. And then I'll place in the file, in the misdemeanor file, that we're going to review misdemeanor on January 26th at 8:30. As part of global resolution.
Yeah, I would anticipate it if Mr. Dunkel follows through with everything he's supposed to, that those will be dates that are now process.
Right. I would too. So we're adjourning file 22-01904 to January 26th. And as a part of that resolution, we will review the misdemeanor file that's currently on the court's docket 22-02185 for the same date. Anything else for the record in docket 22-01904, the felony file, Mr. Whiskey?
No, Your Honor.
Anything, Mr. Carter?
No, you're right.
Okay, you're all set. Thank you for your
Thank
appearance
you.
today.
So I would just inquire, so what is the status of the misdemeanor bench warrant?
It's dismissed. Yeah, I dismissed
Thank you,
it.
Your
Yeah.
Honor.
Guys have a good Thanksgiving.
You too, Mr. Carter. I saw Mr. Nickel here.
They're in a breakout room.
Okay.
And have any of you received a subpoena for anything? Just to watch, just to watch?
So Mr. Nichols in a break in with Mr. Duke? Or-
Yes.
Okay, Miss Duke. So how did you receive the letter?
I got an email. when we were-
What's that?
I got an email when we were in court.
Did you really?
Yeah,
Did you get the full letter or did you get?
yeah, I've got the whole letter.
Okay,
So this would have been at 11:45.
it's about the time that it was. I got it by email and then I got attached the letter to Judge Dragonchuck.
Yeah. So I don't know. I don't see her all that much, but I do what she does.
It depends. It depends on the management style. But now you'll get to see our version. You're familiar with Houghton Hancock politics. Now you get to see our version of that. Yeah, because
Is there some candidate or
Right, we're on the record in docket 21-02940. People of the state of Michigan versus Ariana Duke. This is time set for a probable cause conference and an accompanying PA 53 violation. Will the parties please identify themselves for the record?
Jake Wisty on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Ms. Duke.
And ma'am, you are Ariana Duke?
Yes, sir, I am.
Okay, you can hear me all right, Ms. Duke?
Yes, sir.
All right. Mr. Wisty, this is the time set for a probable cause conference. How are we proceeding?
Your Honor, we've reached a resolution to the matter. Ms. Duke will plead guilty to count 2, domestic violence, second offense. And that would be 1 year and or $1,000 in exchange. The people will dismiss count 1. And that is the extent of the agreement, Your Honor.
Domestic assault, second offense. And that's already a part of there's 2 counts here? Yep.
Yes,
Okay.
that is count 2.
Okay, and so count 1 will be dismissed.
Correct.
So Mr. Nichols, I'll restate it, but it sounds like this is a pretty straightforward plead guilty to count 2, dismiss count 1.
Yes, and I believe the people would also be asking that the court dismiss the pending PA 53 violations.
That is correct.
All right, and the pending.
And I would, at the conclusion of the plea, I will be asking that the court consider releasing Ms. Duke
All right,
pending sentencing.
I do have a newborn that I breastfeed, Your Honor.
all right.
And that would be the reason why we'd be asking
Okay.
for, she has a newborn child that she
Okay.
breastfeeds.
All right. So Ms. Duke, you heard the lawyers speak as to the negotiations concerning this matter, that this is a plea to count 2, dismiss count 1, and then that is the agreement. Also the PA 53 is going to be dismissed, and then I will, not a part of the agreement, but I'll allow counsel to address bond after we do the plea on this file. Is that your understanding, ma'am?
Yes, sir, it is.
All right. Counsel, may I inquire of your client of their advice and rights on
May,
the
Your Honor.
misdemeanor plea? So ma'am, you understand that there's a possible penalty and the ultimate consequences for a plea to the domestic violence case is 93 days and or $500. Do you understand that, ma'am?
Yes, sir, I do.
All right. And if you plead guilty to that, you'll be giving up certain trial rights that you'll have, and I'll walk you through those rights. All right, ma'am?
Yes, sir.
All right. You would be giving up the right to trial by jury. You'll be, or judge, you'd be giving up the right to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question those witnesses. Of course, you are represented today by Public Defender Scott Nickel, and he would be here to contest any charges or cross-examine any witnesses concerning this file at trial. Do you understand that, ma'am?
Yes, sir.
Okay, you'd have the right to have the court order any witnesses in your defense appear at trial. You'd have the right to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. All said and done, if your plea is accepted, you'll give up the claim that the plea was a result of any promises other than the plea agreement or threats that it was not your choice to plead guilty. You'd also be giving up the right to any trial issues. Since we're not having a trial, you'll be pleading guilty to this offense, and therefore we won't have any trial, so there will be no appealable issues. Do you understand that, ma'am?
Yes, sir, I do.
And it is your wish today to plead guilty and to waive your rights to trial?
Yes, sir, it is.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is true to the best? I messed that up, so I got to start again. Would you solemnly swear or affirm that the testimony you're about to give is true to the best ability under penalty of perjury?
Yes, sir, it is.
All right, ma'am. I'm going to bring your attention back to August 26, 2021, at the offense location of 3920 Hartford, City of Lansing, Ingham County, were you at 3920 Hartford, City of Lansing, Ingham County on August 26, 2021?
Yes, I was.
Okay, and what is your relationship with Artinius Smith?
He's my children's father.
All right, and in count two, the allegation is domestic violence upon Artinius Smith. What could you please tell me what you did to make you guilty of domestic violence concerning Mr. Artinius Smith?
As I was trying to pack up my things and leave the household because we were in a dispute, I don't remember about what. I took a can of Vienna sausages that I was feeding my daughter from the car and I threw it at him.
All right, and that was an attempt to hit Mr. Smith with that can of sausages.
Yes, it was.
Okay. Further, ma'am, there's a second offense notice that you were previously convicted of 750.81 parents 2 domestic assault on October 7th, 2020. Do you confirm that you have a previous conviction for domestic assault conduct?
Upon Atrinius? Is it a?
No, just in general.
Just in general, you have a prior conviction for domestic violence.
Oh, I believe I did get locked up for that once, yes.
All right. So that does make this, I didn't say that. So that does make this a 1 year and or $1,000 potential penalty. Is that correct?
Yes.
All right, thank you. Anything towards the factual basis with the enhanced notice, Mr. Whiskey?
No, Your Honor.
I didn't start with the domestic second. I started with domestic first. But I think the defendants indicated they understand it could be a possible penalty of 1 year and or $1,000. Mr. Nickel?
No, nothing further.
Okay. With that understanding, I'm going to refer this to probation.
Okay. For a year?
Well, no, they'll decide how long you're on probation for. What I'm going to do is I'm going to indicate that if you're able to make bond, you're to contact them within 48 hours. So by Tuesday at 5, Tuesday at 4, if you're not able to make bond for whatever reason, then they will contact you. They will come and contact you, okay?
Yes, sir.
All
Could
right.
I-
And then do we have a sentencing date?
January 31st.
Hold on a moment, Ms. Duke.
And the sentencing date is January 31st
At 1:30.
at 2023 at 1:30.
Okay.
By the way, I find the factual basis for the plea to be understanding, voluntarily and accurately made. We've set this for probation, contact by Tuesday at 4, or they will contact the defendant. Sentencing date is set for January 31st, 2023 at 1:30. And Mr. Nichols, would you like to be heard on bond?
Yes, Miss Duke is in the county jail currently. She had a PR bond originally. There were allegations of no contact order violations. Those have been addressed now with this plea. She does have a newborn child who she is breastfeeding. And so I think it's important not only for Ms. Duke, but also for the health of that child that she be out of custody. The alleged no contact order violations revolved around attempts by Ms. Duke to have contact with her children. It's my understanding that the children are now, it appears they're in the courtroom.
Are they? Oh my God.
What's your name?
Can I see my daughter? Can I see them?
Brent.
Okay, they're a friend of hers has them, so she won't have to contact Mr. Smith. She also, it's also some contact that she was having with Amaria Smith, his sister. Amaria Smith now has a PPO against Ms. Duke that Ms. Duke is aware of, was served with. So she understands that she cannot have contact with either Mr. Smith or his sister. And so it's my expectations that there won't be further violations. So I'd ask that the court modify her bond back to a PR bond, allow her to be released pending sentencing, with the understanding that there can be no further violations of the court order that she stay away from Mr. Smith.
Okay, and just for my edification, it was originally a PR bond, a $5,000 PR bond, and then she was remanded on that for the no contact
She was
order.
remanded for the no contact order violation.
All right, Mr. Wisty, pupil's response?
Yes, sure. I would just point out to the court, I mean, these were no contact violations when that was in place. There were some aggressive statements made by Ms. Wolf. Also, part of this is she gave officers trouble, and attempted to resist when she was arrested on them. Given the nature of the child, I think this is a predicament. It would be the people's preference that she be left remanded until sentencing, it would be the discretion of the court. And I would request, if not already done so, she be given a tether if she is released. Your Honor.
Yeah, I guess this is an interesting circumstance because we have the PA 53, but it was dismissed as part of this agreement. I'll indicate PA 53 is dismissed pursuant to agreement. How old is the child? The
My daughter
infant?
just turned 2 on Monday and my son is 3 months.
Okay. And there was an initial PR bond in this matter.
Yes.
All right, so I'm gonna order the following bond conditions. All right, ma'am.
Yes, sir.
We're gonna continue a no contact order with Mr. Smith. So that's Atrinius Smith,
Can
Martinius Smith.
I ask, what about, can we put that for his children too? I don't want him to be able to contact his kids. Cause
It's only
I
as
just.
I'm only putting it as to your contact with him as the victim, okay?
Okay,
And then I'm only putting the no contact order as to him and his sister. You're to have no
Okay.
contact with Imarius Smith.
You'd have to contact friend of the court about him having contact with his children.
Right, you're good, yeah.
well, I got an ex parte order granted that I got full sole legal custody of the kids.
So then
So
that will
I just,
apply.
okay.
And make sure you have a copy of that order, okay?
I
Because
do.
that's the first thing they're gonna look for is a copy of the order. But no contact to Artinius Smith, Imarius Smith, and I'm gonna indicate that since I am gonna PR bond you, ma'am, we're gonna put that on a GPS tether
Okay,
with victim notification. And
Okay.
I'm putting it on victim notification GPS tether because of the PA 53 violation, because the PA 53 violation was pretty apparent that you'd had numerous phone calls to Mr. Smith. And so I want to make sure that you understand that the best thing for you and your family is not to have any contact, direct or indirect, with Mr. Smith. Do you understand that, ma'am?
yes, sir, I do.
Okay, with that understanding, no contact order in place, I'm going to set bond in this matter at PR. I'll return it to the PR $5,000.
Do I get the tether at the jail and how much is it?
I'm not sure how they do that. I think they do that at the county jail, but I'm not sure the price on that.
I don't know the
It's my-
cost. Are you on Medicaid or WIC?
Yes, I am.
If you can get proof or get them your case number, they'll waive the costs.
Okay, is
They
my
will
friend
do it at
there?
the,
I have her cards.
Yep. they will do it at the jail.
Okay,
So as soon as they get the paperwork, they'll contact JSG, which is the company, and their office is sort of in the parking lot of the jail, so they should be able to come right over, okay?
okay, yes.
All right, so right now, we're set to back to PR bond with no contact order. And then we've set sentencing in this case for January 31st at 1:30. Anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Mr. Nickel?
No, Your Honor.
All right, so we'll see you back here on January 31st of 2023. Now, it's important that you contact probation by Tuesday at 4, okay?
Okay, yes, sir. Thank you so much, Your Honor.
All right. That's all for the record in this file.
Thank you.
Can you tell them to come to the jail? My friend, can you tell them to come, because they have my,
I'll talk to her, Miss Duke.
We're coming.
okay.
Me and the baby.
Yay! I got
Yeah, it is. I think the light's off in their room. I think we can see the phone. Looks like we can see the phone. They have a pretty view though. Those windows.
That he indicates. So we're on the record in docket 21-00671. That's people of the state of Michigan versus Bridget Franklin. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Erin Robinson, Assistant Public Defender for Ms. Franklin.
This is the time set for a competency hearing, and I'm in possession of a letter and a report. The report is an indication And first of all, I'll get council's take. They also received the report and the letter. Mr. Whiskey, how are we proceeding today?
Your Honor, we'd like this set for a pre-trial, I guess, far enough out so we can anticipate we'd have the competency or the responsibility report completed. I do believe that is necessary before we proceed in this case.
All right, so and we do have the competency report, and I will sign the order indicating that in the author's opinion, the defendant is competent to stand trial. We also received a letter dated November 17th from the forensic facility indicating that Ms. Franklin had been interviewed, but the report was not finished as to criminal responsibility. Ms. Robinson?
Yes, Your Honor, we have no objection to, the findings that are in the report, and we would just ask for a pretrial date as well, understanding that that report is still outstanding.
Right, so I've signed the order for competency. The defendant's been found competent pursuant to the report. And then we will set for a pretrial, understanding criminal responsibility is still outstanding. And we'll set, so I'm gonna assign the order of competency. Criminal responsibility to follow. And we'll set more as a control date, anything, a new pretrial date, and we'll set it out to give some time to get the report in. I don't know, what do you think?
What did the letter say?
It indicated that she'd been interviewed on November 10th, so that was a week ago. I'd still like to give 3 to 4 weeks. I mean, just.
Yeah, it's my understanding that it seems that from the letter that he's waiting on some records, and I believe it's from the last time that she was involuntarily committed. So I think they're probably important records.
Right.
But I'm assuming they've already been requested likely before the interview happened. So assuming everybody's doing their job, 3 to 4 weeks should be fine.
Yeah, let's do 30 days out. Well, find something in the vicinity.
We either have 15th of December, which is about 20 days.
Let's go out.
Um,
Because there's no reason to set a date where nothing's ready. I mean, it doesn't.
January 23rd
That's perfect. January 23rd
at 9.
at 9 a.m. for a second pretrial and awaiting report for criminal responsibility.
And she should still be at Kalamazoo because she is committed there.
Okay. All right, so so she doesn't need to be here for the pretrial, right? I mean, so.
I'm fine with that.
Yeah,
I'll waive her
all right.
appearance.
All right, anything else for the record in docket 21-00671, Mr. Wisty?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, thank you. So you're all set. Ms. Franklin, you're free to leave the Zoom courtroom, and we'll wait for the criminal responsibility report, and we'll have a second pretrial on January 23rd. All right, ma'am?
All right.
Thank you.
January 23rd.
All right. Well, big county changes the day before Thanksgiving.
I don't know. I guess it's not going to affect my day to day, probably.
It will not. It will not.
Unless, I don't know.
No.
I can do about it, I suppose.
No, I agree.
Creating drama, though.
It makes it makes for a lot of water cooler talk.
And I had a question. So the week after Christmas, which would be the 26th, the board is off on Monday and Friday, is that correct?
Probably,
Maybe a better question for you.
probably. I don't know.
hang on just a second. I think you're right.
I think that Monday is the holiday for Christmas.
And I think that Friday is the holiday for New Year's Eve.
So what is,
Yeah, it's
Yeah.
Friday and the Monday after too, because
So-
I'm on arraignments all 4 days.
I guess is, what's gonna happen Tuesday and Wednesday is a chance that that gets mixed up like for Thanksgiving, just for purposes of letting. them know.
What is happening Tuesday, Wednesday? That's a good question.
Well, Tuesday would be which,
An ordinance day
Tuesday's an ordinance day.
of the 20, it would be the 27th.
Yeah, so that. thanks you,
We'll see, Aaron.
So Tuesday's an ordinance day, Wednesday's the day I
Landlord.
don't like.
Is that landlord tenant?
Yes, and Thursday's the PCC and exam day.
Okay, so just like. normal.
The same,
Yeah.
yeah.
Thank you.
The only
Well,
time
that's
that
a
we
good
do this
question.
particular trip is on Thanksgiving,
Okay.
unless Christmas and Christmas and New Year's falls funny. But- But this, it only happens once every 7 years, Jay.
You got it calculated out like that?
Here's, I don't know where that came from. Mr.
Back.
What's that? That's yours. That's on the factual basis of one of Mr. Nichols' no contest. Is it?
Oh my God. look at that.
It's fine.
I don't know.
Have a nice Thanksgiving, Mr. Wisty.